Great. Good morning and welcome to the webinar on agreement making and commercial contracts. My name is Michelle and I'll be your webinar moderator today. Today you'll be hearing from Lewis Izzo, Managing Director at Australian Business Lawyers and Advisors, and Kate Thompson, Senior Associate at Australian Business Lawyers and Advisors. They will discuss how to approach EA negotiations and review business contracts. Like always, we'd love to hear from you during today's presentation. If you have a question, please feel free to type in your questions in the Q&A section at the bottom of your screen. You may send in your questions at any time during the presentation, and we'll be answering the questions at the end of the session. So welcome, Kate and Lewis, and over to you.
Thank you very much, and welcome everyone to our presentation. Hi, Kate. How are you going from sunny Newcastle?
Good, thank you, except not very sunny up here. I'm not sure about you guys in Sydney, but lucky we're all here together. A much better way to spend the morning.
Excellent. Well, we've got a bit of a jam-packed schedule for this morning. There's been a range of IR reforms late last year pertaining to various parts of the Fair Work Act. And so the goal today is to take NatRoads members through the reforms to explain not only what the changes are, but the way in which they might affect NatRoads members in their own business. We've got a relatively busy agenda. So we're going to start with flexible work requests and the changes there. We've included parental leave extension requests, but we don't really need to dwell on that significantly. I think it's less of an issue for NatRoads members because parental leave extension requests are less common. I think tend to get handled reasonably well in businesses, but flexible work requests, we really do need to ensure you're across. Absolutely need to ensure that businesses are across the bargaining reforms because we're expecting heightened level of activity in terms of enterprise bargaining and also arbitration of bargaining disputes. We're going to talk a bit about the better overall test, as well as the new laws about terminating EAs and the extent to which you can. Unfortunately, it is now going to be quite difficult. And then we need to go completely in a different direction and get members across the respective work changes because there's a fair bit to be done to ensure businesses are compliant in that space. And then we're going to talk a little bit about contracting at the end. So there's a fair few things to talk about. I might hand over to Kate, who's a Senior Associate in our Newcastle office, to kick off and talk about flexible work.
Yeah, thanks, Lewis. So as you said, there's two sort of components to this. There's the flexible work requests and then the parental leave extension requests. I'll talk a bit about parental leave extension in a second. But as you said, it's probably the most relevant and the most immediately apparent thing to think about for members is the new flexible work request entitlement. So under the Fair Work Act, employees have always had the right to request a flexible working arrangement, provided they met one of the criteria. And there's a range of criteria that you need to satisfy in order to be able to make a request. Things like someone with a disability, people who have kids who are at school, people who have caring responsibilities, people aged over 55, a whole range of people who are eligible to make those requests. Now, previously, the benefit for employers was really the only obligation we had was to reasonably consider the request and provide a response to the employee. So if it didn't suit you, if you couldn't accommodate it, well, as long as you told the employee that you'd thought about it, that was where the discussion ended. Now, from 7th of June, so that's 6 months after the Fair Work Act amendments commence, and you'll hear us talking a little bit about a couple of key dates. Really, we're talking about 7th of June and then probably 7th of December later on this year for the things you need to be worried about. We have a much broader entitlement for employees to make a request and to have that request dealt with in a particular way. And I'll talk a little bit about that in a second. So the first thing to note as well, there's new categories of employees who are entitled to make requests. So you can see pregnant employees and people who are either themselves or have someone in their immediate family experiencing family and domestic violence are now entitled to make those requests. So just keep that in the backs of your mind. But the main thing that we need to be worried about here is the process that we need to go through and the increased entitlement of employees to have the matter or their applications dealt with by the third-party arbitrator, which is the Fair Work Commission, if they don't like your response. So I'll talk you through the process a little bit. It is quite an involved process as well. So there's two things we need to be worried about here. Firstly, are we complying with the process that we need to go through? And secondly, are we dealing with the application in a way that's going to be legally compliant? And if we end up in the Fair Work Commission, we're going to be able to defend our position that we've arrived at. So very, very long story short, the process goes basically as follows. The employee needs to make a request in writing to you, telling you why they need the request or why they're making the request, the grounds that they're relying on. So as I said before, they need to tell you why they fit into one of those categories that entitles them to make that request. You have 21 days from the date that person makes that request to provide a response. So if you say, yep, that sounds fine, no worries, all good, let's do that, you can respond in writing. That's the end of the story. Everyone moves on, happy days. If you're intending to say no, or if you don't think that the request is going to be able to be accommodated, you need to meet with the employee to discuss the request. So at that point, you might say, yeah, okay, no worries, sorted it out, understand why you need it, all good. Again, you need to respond in writing and confirm that you've agreed to the request. If at that point you're still saying, no, probably can't accommodate that, there's two things we need to be conscious of at that point in time. So firstly, you've made a genuine attempt to agree. So again, you can't just kind of say, nah, doesn't suit me. Sorry, too bad, too sad. You've actually got to say, well, it doesn't suit me because our roster doesn't permit for that, or I need someone at the location within that period of time, or that spread of hours, or whatever the case might be. We need to have given genuine consideration to the request and made a genuine attempt to agree. We need to have regard to the consequences of refusal for that person as well. So have we actually thought about what saying no will mean for that person? Does it mean, for example, they need to pay extra money in childcare? Does it mean that they might shorten their working life with us because they might transition to retirement earlier on because they can't continue working full-time hours? And if we're going to ultimately, after all of those things, still decide to refuse the request, we need to make sure that's on reasonable business grounds. So we need to actually say in writing, these are the grounds that we've considered and these are the reasons why we can't actually accommodate your request. And as part of that, one of the things that we really need to be considering as well is alternative solutions that we might suggest to the employee. So they might be suggesting something to you which is way out there and you go, well, no, absolutely not, can't accommodate that for our reasonable business grounds, but here's a compromise position that we could propose to accommodate. How do you feel about that? Those are all the steps that we need to take to ensure that if the employee is still unhappy with our decision at the end of it, which is what I'm going to talk about in a second, we'll have put ourselves in the best possible position before we get to the Fair Work Commission, who can now have the power to firstly mediate these applications or conciliate. So they'll sit the parties down and have a discussion about what's going on. And then finally, if, at the end of that process, the parties are still unable to come to an agreement, they can arbitrate those disputes and they can enforce a decision on you that, might ultimately cause significant difficulties for the business, but the third party is able to come in and impose that decision on you. And that's something that we'll see a little bit more later on in the presentation, this capacity of the Commission to come in and make these decisions for you in a way that they haven't had that capability previously. So the other outcome that might happen is even if you don't respond within that 21-day time period, and that's the relevant period that we need to be concerned about in terms of our response, the Commission can also take that step to impose an outcome on you in that circumstance as well. So there's the two situations, one where you can't agree with the employee and two where you don't respond within the relevant period of time.
So I think sorry to cut you off, Kate.
No, you're right, go on.
This is where the real change is that currently employees can't have a third party intervene and force an outcome on the business. Now you will need to be able to demonstrate there are legitimate and tangible grounds as to why you can't accommodate something, because otherwise the Commission can impose the request on you. And so what we need to move away from, which is kind of what Kate's been talking about, is this kind of gut reaction that something doesn't work for your business. You really need to have tangible, objective material you're going to refer to, whether it's data or other concepts, you say, no, we can't actually accommodate this because of X, Y, and Z. You can't just say, well, it's not productive for someone to be working from home. You're going to have to be able to demonstrate why it doesn't work for this business if you're going to successfully resist these types of requests.
Yeah, that's right. And we've already had, whilst not under these provisions, under enterprise agreement dispute provisions, a decision of the Commission come down in the last little while, which basically was very critical of an employer who I personally think was Ambulance Victoria, had, you know, legitimate reasons for saying, no, we can't accommodate this person's request. And the Commission member in that case said, you know, this computer says no response isn't just not going to be sufficient anymore. So it's exactly what Lewis is saying. You know, we need to move away from just saying, no, it's all a bit difficult for us, to actually being able to say, well, no, we can't accommodate it for these reasons, or here's an alternative that we can accommodate. So, and also I think the procedure is one of those really major changes as well. We just need to be really on top of what we need to do from a process perspective.
And so with that in mind, before we move off, NatRoads and ABLA have actually combined together. We've developed a procedure for managers that members can purchase and have access to. So basically what it is, it's a 7 to 8 page procedure which sets out from beginning to end what you need to do, what you need to consider, and it then contains template letters at the end that you can use to either accept, reject, or propose a new flexible working arrangement. And that's all been incorporated together, and ABLA and NatRoads have kind of combined to put together that procedure for businesses. Because what we want to do is ensure that the line managers in these business that are probably going to be the ones who actually get the requests are armed and know what to do. So it's all very good for business owners or potentially someone who deals with HR issues to be across it, but who's going to be dealing with these requests? And whoever's dealing with it will need a clear process to follow. And so we have worked on something, and members can reach out if they want that direct.
Yeah.
So Kate, I think we can probably move
on
pretty quickly through the parental leave stuff.
That's okay. Yeah, so I'll just mention here as well. So hopefully everyone's aware of the entitlement to 12 months unpaid leave as in the first instance for someone who's eligible to take parental leave. Again, people have always had the capacity to request a second 12-month period, like flexible work arrangements. It's always been a situation where if it didn't suit you, you could kind of just say that, and then the employee would have to make a decision based on that information as to whether they return to work or perhaps resign from their employment. Similarly, now we just need to basically explain our decision-making processes, what would be an appropriate extension if we're unable to accommodate the extension that the employee sought, and do all of that in writing, and tell the employee that they're able to challenge the right of challenge any refusal under the Fair Work Act as well. So probably just highlighting something to be aware of. If you've got someone potentially coming back from parental leave, this is a 7 June starting point as well.
All right, so enterprise bargaining, this is where there's going to be a considerable shift for businesses in road transport. What you'd understand of enterprise bargaining currently is what's in box 1 there on your slide. That is single employer bargaining. So a business bargains with its workforce or with a union or a couple of unions for an enterprise agreement. That existed before the reforms and continues to exist. And there's not, or aside from one big change I'm going to come to about arbitrating outcomes, that regime exists pretty much today as it did before. Where there has been a big shift in the IR landscape is on this new capacity for multiple employers to bargain together. Now, in two kind of ways, there's reforms that won't really touch upon road transport much. So I might deal with them first, and that's box 3 and box 4 up on your slide. So there's a new supported bargaining stream for lower paid industries that haven't traditionally bargained. Think about the aged care sector, social community, housing, disability services. Think about the childcare sector, potentially cleaning, security. For that industry that hasn't really had bargaining traditionally, there is a new stream that can compel employers to bargain together in that industry. That's probably not going to have a huge impact on road transport, albeit that some people in your supply chain might be caught up by it, for instance, security contractors, things like that. There's also the 4th box there, which is cooperative workplace bargaining, which is where multiple employers bargain together, and then other employers are asked to be roped into their EA by consent. Again, unlikely to have a huge impact in road transport, because this is where employers want to do this, and the employers need to genuinely seek out adding themselves to an existing agreement. It might happen a little bit, but it's really a voluntary opt-in process. So that's not really where the concern comes. The biggest box is box 2, which is a new brand of bargaining called single interest authorisation bargaining. And if I can ask Kate to forward through a couple of slides to the next one. It's quite a one back. It's quite a complicated test, and single interest authorisation bargaining involves a scenario where the employees in a business, a majority of them say, we want to bargain not just with our employer, but with other employers also in the industry. And provided a majority of your employees want to bargain with the majority of the other employees in a different business, and provided the commission satisfied there is clearly identifiable common interests, the commission can fuse the employers together and force them to bargain together. And so what might happen is you might get a bunch of employees in different road transport companies saying, I don't want to just bargain with my boss, I want to bargain with a range of businesses altogether because we want some of their terms and some of their terms, and we actually think collectively we can negotiate a better outcome. And provided they can show that you're broadly under the same regulatory regime or the similar geographic location or nature of the businesses is the same, then that common interest that the Act talks about, there being clearly identifiable common interests, may be triggered so that you can be fused together. And if that's triggered, then the employer can only resist this push to multi-bargaining if they can show that the bargaining's against the public interest. And that would be quite a high threshold. And so there is a real concern that if you are operating in particular in the road transport industry or similar industries, it might be that the TWU doesn't target you individually. It seeks to get an uplift in conditions across the board by targeting a range of businesses together. And the only way you can be exempt from that is if you're a small business, and you'll see up there 20 employees or less, or really the last one, which is you're covered by an EA that hasn't passed its nominal expiry date yet. So there's a way to get out of this, which is that there's an EA already in place that's current, its term hasn't expired, then you can't be subject to bargaining until it expires. But even then there is some risk, because once it expires, then it's possible that you can be still roped into multi-bargaining. There is a grace period of 9 months during which the commission has a discretion as to whether it lets you in to multi-employer bargaining or whether it allows you to still go your own way. But once that 9-month grace period expires, after your EA has expired, you can again be exposed to this multi-employer bargaining. And it's not just bargaining. So there's this prospect of two employers or multiple employers being fused together to bargain. But if we go to the next slide, there's also this roping in concept. So it may be that other employers have actually reached a bargain between them. And what they seek to do is go to your workforce, the union will go to your workforce and say, we've already got an EA in place. It's got good rates, it's got good conditions. Why don't you vote as a workforce to be added to that EA? And then there's no bargaining process at all. Again, provided there's a clearly identifiable common interest, provided the majority of your employees want to be fused in to this, or roped in, I should say, to this other bargain, then as long as it's not against the common interest, the public interest, you can have your business roped in and subject to another EA that's already been made, another multi-EA. And this is where we think the unions are really going to target, because what they can do is they can probably go to a couple of major players in the industry, say a Linfox or a Toll, make a multi-agreement with those employers, which may well be on higher or more expensive terms and conditions than what you're used to. And then they can go business by business and get employees or a majority of employees to vote to be added on to the existing industry agreement. And what you might find is that the price of labour across the board goes up as the union adds more and more businesses to its industry agreement. And so this is where we're seeing quite a significant prospect of change in the road transport industry in particular. And as I said, there's really only two ways to get out of it. One is to have your own EA in place, and then you're automatically insulated for the life of that EA, or to be bargaining for a new one within 9 months to relock yourself in for another EA. And during that period, the Commission has a discretion whether to fuse you to other agreements or not. So we do see a real risk, we think, of the TWU being quite active in this space. We've spoken to the TWU, they've been very coy about what their plans are. They're almost pretending these laws don't exist when we've asked them about their intentions. They've been very quiet. They're saying, oh, we haven't worked out what we're doing yet. But I actually think that they have some quite concrete plans in place, and they're probably going to look to put in place some multi-employer agreements and seek to target companies, either collectively to all bargain together, or alternatively get the multi-agreement up and then target companies one by one to rope them in. And they'll use it as a membership drive, because what they'll do is they'll ask employers to join the union, and if they join, then the TWU will say, well, we can get you these terms and conditions that are already in this agreement here. And if you think about it, it's a great recruitment tool, because currently unions have to convince workers to sign up to then bargain for better terms. This whole roping in concept doesn't involve any bargaining. What it involves is an agreement that's already been made and saying, well, if we can get a majority of you to sign up and to agree, we'll just apply this agreement from another business or other businesses to your workforce. And I think that's there's a level of attraction to that, because there's a level of certainty as to what's going to be applied for the employees. And so I think this is a big concern for the industry going forward. And you need to start thinking about risk mitigation measures. How are you going to insulate yourself from this? Are you going to bargain for your own EA? Are you going to drive better engagement with your workforce, try to ensure there's mechanisms in place to keep people more engaged, to stop the union from penetrating into the workforce? But you need to start thinking about what it is that you're going to do, because these changes are coming on the 7th of June.
Hey, Lewis,
so
we had a couple of questions, which is probably a good opportunity just to cover them off now before you move on. So I'll ask you and you can just clarify for us. The first one was, is it a law or a requirement that a transport company is required to do an EA, or would you just say it's encouraged?
No, it's definitely not a law. You don't have to enter into an EA, not at all. But what happens if you don't is that you may be subject to this multi-bargaining. And so you really need to make a judgment call as to whether you think, no, my workforce has got a good level of engagement. If there's issues arising, we've got good grievance processes to deal with it. They think they're fairly remunerated. If you think you can promote good engagement, you can run the gauntlet and maybe successfully stop you being exposed to the union pushing for multi-agreements. Alternatively, if you think you are at risk of being exposed to this, you might want an EA to stop you from being subject to a multi-enterprise agreement. But what is compulsory is, once a majority of your employees vote for a multi-EA, if there's a clearly identifiable common interest between you and the other businesses that are subject of this multi-employer application, you will be roped in against your will. And so that's why you need to think, can I carry the day with my workforce and convince them to stay out just under contracts of employment or letters of offer? Or should I jump into an EA to ensure I at least get my own terms and conditions? Because one of the other dangers with multi-bargaining is, once you're in multi-bargaining, it's very hard in terms of negotiating the outcome, because a vote, you can't proceed to a vote unless the union agrees to go to vote, or you go and get an order from the Fair Work Commission permitting you to take the EA to vote. So the multi-bargaining regime is very much going to be controlled by the union. And obviously, make no mistake, this is about increasing unionisation in various industries. And so you really need to make a judgment call as to whether an EA is going to help you stay completely outside of this new regime. And obviously, if you do decide to go down to the EA path, you can contact NatRoads, get some help from the NatRoads workplace advisors that can help with queries in that regard. ABLA is also providing a discounted offering to NatRoads members for providing services associated with bargaining. But so there's support there if you need it, but you just need to weigh up what the best call for your business is.
Yeah. And the second question was, what's the benefits of doing an EA versus what are the downsides? I think you've talked a bit about what are the benefits. Obviously, it gets us out of the single interest authorization stream. And I think we'll talk a bit about what some of the potential downsides are in a little while when we start to talk about termination of EAs, in that it basically locks you into having an EA moving forward now. Are there any others that you can just identify for us quickly?
I think there are downsides. You are locked in. It's very difficult to terminate EAs now. Moreover, when your EA expires, a bargaining rep for the previous EA can automatically just request to start bargaining again. So you're really locked into this cyclical, periodic process of bargaining with your workforce. And bargaining pits the two parties against each other. It pits the employer against the workers. The workers are encouraged to make claims. The employer's got to respond to those claims. So you're committing to this kind of every 3 or 4 year process of a level of agitation in the workforce, a level of claim and counterclaim, and you're going to be locked into that indefinitely. And that's the downside to bargaining. The question is, what's worse? Is do you think you'll have something else imposed on you if you don't go your own way? Do you think you can hold out, or is preferable to hold out? And that's the consideration each business needs to take.
Yeah. I've got another one as well. This is another potential downside. So arbitration. So like we were talking about originally on earlier on in the presentation, this increased capacity of the Fair Work Commission to basically come in now and impose decisions on businesses in ways that they previously haven't been able to. So we saw how that works in relation to flexible work requests. If we're thinking about downsides for bargaining, this is probably one to be conscious of as well. So you can see there in the Fair Work Act, there's always been the capacity for the Fair Work Commission to be involved in bargaining disputes. Parties had the capacity to make an application under Section 240 for the Commission to deal with a bargaining dispute. You would have seen some of those in the media. They're fairly high profile sometimes because they usually involve high profile employers and very conflict driven bargaining processes. But now what's happened is the Commission will have this sting in its tail at the end of that process if the parties are unable to resolve the outstanding issues with respect to the EA, in the process of conciliation. So how this might work is, you've been bargaining, you might decide you're going to start bargaining for your own EA. To avoid any of the multi-employer stuff, you start to engage with your workforce, with the unions, if that's applicable to you. You get down the track and you might even get to a point where you have 90% of the issues outstanding resolved, and there's only those sort of 5 or 10 thorny ones, probably rates of pay, that's quite often our experience, that remain outstanding. You reach a stalemate, and then now what we've got the capacity to see is a party involved in that bargaining process. So important to note at that point in time, it might be you as the employer. You can exercise your right to seek the assistance of the Commission in this way just as much as the employees or the unions can. But you can request, or someone can request, the assistance of the Commission. So how that works is it has to be 9 months after bargaining's commenced, or 9 months after the nominal expiry date of an EA if you had one in place previously. So you've got that little bit of time to say, well, let us sort things out ourselves. We're not going to run off to the Commission straight away. So if you do have an expired EA or an EA about to expire, or you are thinking about bargaining, be conscious of that 9-month time period and be conscious of the fact that if you can get things sorted within that period of time, you'll be doing well for yourself. The Commission then needs to conciliate, as I said, and if they think that there's no reasonable prospect of an agreement being reached, the Commission can issue, upon application by one of the bargaining representatives, what's called an intractable bargaining declaration. So that basically means parties can't sort things out by themselves. What happens from there is, a variety of things, as you can see in that green box down there. So there's a post-declaration negotiation period, which is, the last hurrah, the last chance to try and resolve things between the parties before the commission takes it out of your hands and says, no, well, you guys can't sort it out, so we're going to sort it out for you. If you get to the end of that period of time and you're still not able to sort out whatever it is, the commission will arbitrate the matters in dispute. So anything that's outstanding, and they will consider all of those things on their merits. Productivity is only one thing that they will have regard to. So that's a really important consideration there. So, quite often we see employers saying, well, if we need to see some productivity improvements in response, or to reward employees with the claims that they're seeking. Otherwise, we can't afford this, or it's not worth our while. The commission will have regard to that, but they can have regard to a whole heap of other factors as well. So basically, it's just another example of how there's definitely an increased encouragement on parties to try and negotiate, try and get things sorted between themselves, but the commission is going to be able to step in at that final stage and say, well, if you guys can't sort it out, we're going to sort it out for you.
And so I think this is going to work in two ways. Where a business struggles to get employee consent for an EA without the union's approval. So you've got a highly industrialized workforce where the union kind of controls the vote. This can be a real tool, because you can say, well, I don't now need to win the union over and the employees over. I can just go to an arbitration on this, getting this restrictive condition out of my EA. But where you don't have high union density and where you can tend to win the vote with employees, this is where unions will likely use it as a tool. And they can say, well, now we don't need to worry about running a no campaign. If we can hold out 9 months and we disagree on pay, we're at 6%, the employers at 3%. We can just ask for it to be arbitrated and hopefully get the commission to determine somewhere in the middle. And then once the commission determines, that outcome is imposed on you as if it's an EA for 3 years, 4 years, whatever the commission determines. So it really gives the party that doesn't have the power at the moment in terms of carrying the day with a vote, it gives them the ability to try and impose a different outcome in a different way. But it's probably going to give significant power to the unions for those businesses that haven't had to deal with unions much, that the union doesn't have strong density. This is another bow to their arrow that they'll be able to rely upon. So it's going to be interesting to see how it unfolds, but it's going to make bargaining a little bit more fortunate for some.
Higher stakes, I think. None of our, let's wait and see, and war of attrition kind of approach won't be as available. I'd just like to talk quickly about the boot. You might have seen, I think this was one of the areas where the government sort of said, oh, look, we're making bargaining easier. We're going to make more people involved in it, so let's make it easier for everyone. Whether that's actually true or not remains to be seen, but it's important, particularly if you have experience in bargaining under the Fair Work Act regime, to be aware of what this all looks like for you and the implications of that on the process. So the Better Off Overall test is the test that the Commission applies when an agreement is submitted to it for approval. They have regard to the underpinning modern award or awards and go, okay, employees covered by this agreement, are they now better off overall as compared to that award or awards? The issue that we've had is that due to a couple of agreements being approved that hit the headlines that perhaps didn't result in employees being better off overall, the Commission has in the last 4 or 5 years, probably 5 years now, time goes on, taken quite a forensic line-by-line approach to the boot, which means that it's quite difficult and has been historically quite difficult for employers to actually get any benefit out of the bargaining process, because if you're comparing line by line with the award, where's the capacity to trade off some of those award entitlements for things like higher rates of pay? Those were the issues that clients and members were experiencing. So the government said, no, okay, let's take a step back from that approach and focus on whether employees are better off globally under the proposed EA, as opposed to the conditions that they would enjoy under the underlying award. The other thing that we had difficulty with was that the Fair Work Commission was required to consider prospective employees. So not only the employees that you engaged at the time that you negotiated the EA and the patterns of work that those people were working, but also people that you could potentially engage in the future and see whether or not those people would be better off as compared to the award under your EA. So you can really imagine there, we're negotiating an EA that suits our business needs at the moment. We might build in some flexibility to give us some rostering patterns that we might not have working at the moment. But, you know, it's kind of based on the business's operational requirements. The Commission was coming in and saying, well, no, hang on, you could engage a part-timer only on Sundays, and that person would be worse off under your proposed EA. So that's the prospective employees thing, and that's the difficulty that it ended up causing for people engaged in bargaining. So they're going to step away from that. Let's not worry about those prospective employees or all categories of prospective employees anymore. We're only going to need to worry about reasonably foreseeable employees and patterns of work that are reasonably foreseeable at the test time. So the test time is when the Commission, when the agreement is voted up by the employees and when the agreement goes to the Commission for approval. So that's the time that they need to be worried about. They will be able to look at classes of employees as well. So that's, you know, not just looking at individual employees who might have a particular pattern of work, but generally overall groups of employees working a particular roster or at a particular location. The other important thing is they will be able to give and indeed need to give primary consideration to a common view, if any, relating to the boot expressed by particular bargaining representatives. So at the moment, the peculiar situation that we have sometimes arise is even the union will come along and say, no, we think the agreement's fine. It's all good. We support it. We think it suits our members' needs, and we think if the Commission should approve it. The Commission can still decide that they don't really care what the union has to say, and it's their statutory obligation to apply the boot in the way that I've just gone through. So the fact that the union or the employees are supportive of the approval of the agreement isn't really a compelling factor to the approval decision. Now, so they'll have to give that primary consideration. If you've been through the process, you know, in the last sort of 5 to 10 years, you will perhaps be familiar with the idea of needing to provide an undertaking. So this is the last chance saloon. If you have an agreement which gets to the Commission now, whereby the Commission has a concern it doesn't meet the boot, or there's a particular concern about particular classes of or particular individuals of employees, we provide an undertaking, which is basically something that says the agreement will apply in a particular way or a different way. Now the Commission will have the capacity to say, don't like that, going to apply that in a different way. They don't even need to ask the parties or the employer or the applicant for their view on that. Lewis, is that kind of a...
Yeah, no, so I think, and yeah, so I think in terms of all of that detail, that the reality is it will be easier to get boot, which is a good thing. There is on this slide the reconsideration test, which I'm happy to just briefly address, which is that at any time an employee feels that their pattern of work wouldn't pass the boot, even after the agreement's approved, they can have the EA reconsidered. That is of some concern because it means your EA is no longer locked in for the life of the term. An employee can come and work a new pattern of work and say, oh, hang on, my pattern doesn't quite pass the boot if you look at what I'm doing in terms of my hours. And the Commission can then reconsider the boot and actually ask the employer to give undertakings or just vary the EA itself to ensure any new patterns of work don't end up worse off other than under the award. So I think what we're seeing is if you're sailing very close to the line in terms of the boot test, it is a bit of a concern, these changes, because your EA could be challenged at any particular point in time. If you're well above, it's less of a concern. But I think there's going to just need to be a little bit more focus on the patterns of work that are being done, ensuring they're clearly communicated, and that should help to at least get it over the line initially. We're just going to have to live with a new reality that if patterns of work change significantly, you just need to be conscious that the EA can be changed during its life if employers end up worse off when compared to the award. But that's something we're just going to have to live with. I suppose that feeds into EA terminations. Kate, the overarching message here is that it's just going to be much harder to terminate as well.
Yeah, unless you have a zombie EA, in which case you've got no choice. So anyone who perhaps has a zombie EA, so is an EA that predates the Fair Work Act, so before 2009, 2010, you need to be conscious of the fact that your EA will sunset as of the 7th of December this year. So that means it will cease to apply as a legal instrument unless you seek an extension to the Commission. So if you've got a zombie EA, really need to be starting to think about what you'd like to do now. Are you going to apply for an extension? Have you got the grounds to make that type of application? Or would you prefer just to go, all right, this is perhaps a good opportunity for us to start bargaining for a new agreement, which you're more than entitled to do because your EA is long past its nominal expiry date. So that's zombie EAs. So if you've got one of those, lots to think about. Termination by consent is something that will always be available. The provisions are largely unchanged, but as Lewis has alluded to, unilateral termination is one of the main areas where we've seen change that's already commenced. So, traditionally under the Fair Work Act, the Commission has had the capacity to terminate an EA either before it passed its nominal expiry date or after it passed its nominal expiry date. Different tests depending on where we were up to in the life of the EA, but what happened was some unions in particular were getting a bit cross that employers were going down the path of terminating their EA in circumstances where negotiations for new EAs were becoming quite intractable and difficult to progress. So how that worked out was, we'd start negotiating for a replacement. Things weren't working out, the employer would then go, well, this is untenable, let's apply for a termination. At least then we'll go back to the award and we can do away with whatever it was in that EA that's no longer suiting our needs and is perhaps one of the reasons why we're looking to create a new EA. Now, under the brave new world, what we'll need to establish to the Commission is that there's a significant threat to the viability of the business, and that significant threat basically is going to mean that the business is going to shut down unless the EA is terminated by the Commission. So that's the threshold that we're at, that the termination is necessary to reduce likely terminations of employment. So unless you have the EA terminated, you're going to need to make people redundant. You will also need to guarantee all of those termination entitlements. So it's not going to be good enough to come along and say, well, I'm going to have to make all these people redundant. You're going to have to be able to stump up and say, yep, even if we do need to terminate people's employment, we've got the cash and the reserves to be able to make sure those people are looked after. And then finally, it must be appropriate in all the circumstances. So what that means, we'll have to wait and see. But the long and the short of it is that once we have EAs in place now, it's going to be very, very difficult to get out of it. Whether that's a single EA that you've entered into with your workforce and any bargaining representatives, or an EA that you've been roped into or participated in as part of one of the multi-employer streams.
Yeah, and I think that's the point, and that's the downside we mentioned earlier. Once in, you're locked in for life. I wanted to completely change focus now. There have been other reforms, quite significant in relation to respect at work. So most of you would be aware of the discrimination laws and sexual harassment laws that apply. They've been somewhat expanded. There's now a definition of sex-based harassment in the discrimination laws, which talks not only about sexual conduct, but demeaning behaviour based on someone's gender or sex. And that can go both ways. It could be a demeaning comment made to a female. Often people may hear crass jokes about someone being a blonde or having something like that. That would be sex-based harassment. Or to males, calling someone pale, male and stale or something to that effect. Any kind of gender-based demeaning conduct is now illegal. There's also an ability to seek stop sexual harassment orders from the Fair Work Commission. But by far the biggest change is there is now a positive duty that's been introduced to prevent all forms of sexual harassment in the workplace. Now, what that means is it's not good enough to have a policy or even training and to respond to complaints when they arise. From 7th of March, you will need, like a safety based issue, to have a regime in place that ensures that you are taking all reasonable and proportionate measures to eliminate sexual harassment in the workplace. And so what we're seeing, and this positive duty currently exists in Victoria, in that state, and what we've seen from the regulator down there is that policies aren't enough, training's not enough. What they expect is that employers will treat it like a safety issue. If you think about slips, trips and falls, or even something basic as sanitisation, you've got signs up in a kitchen saying, or bathroom, wash your hands. You've got signs in a loading dock that talk about make sure you walk in the pedestrian area. There's multiple measures that are taken to prevent certain unsafe conduct. And it's the same here. You'll need to do a risk assessment. You'll need to do a prevention plan about all the places where employees may be subject to exposure to sexual harassment. And what is it that you're doing to actually eliminate the risk of that harassment? Do you have education in place? Do you have policies? Have you trained people? Have you got other measures in place where you think the risk is somewhat higher? Have you got clear grievance process and advertising that so any poor behaviours can be brought to focus? Are you doing some kind of periodic monitoring by way of engagement surveys? All of these types of things are now things employers need to think about. And ultimately, it comes down to having a regime, a comprehensive regime in place to eliminate this behaviour. And think about it in the safety context. If you have a serious safety incident at work, if you have a fatality, I read tragically this morning or yesterday that an 8-year-old boy got electrocuted in Fiji, at a resort in Fiji. That's a very sad, tragic event. What happens in those types of scenarios? A regulator now comes in and they're not asking about that very event. They're saying, what are your processes in place? What did you do about the way you deal with these types of facilities or plant generally? What type of training do you have? What type of measures are in place? What type of hazard identification is in place? All of that. And often in these safety scenarios, if employers haven't had quite a prescriptive regime in place, they will be found short, they'll be found wanting. And it's the same with road safety, it's the same with fatigue, you'd be aware. It's not good enough to expect people to do the right thing. You need to have a documented process. And that's what's going to be required in the sex harassment space. And it's a little bit daunting. We're trying to help members with this. So again, ABLA and NatRoads have teamed up. We've developed a comprehensive Respect at Work toolkit that goes through what your obligations are. It's got up to 15 policies, emails, templates that are built into it that you can utilise to implement things in your business. It's got a kind of step-by-step prevention plan, guides that you can use, an equal opportunity policy you can use to try to ensure that you have a documented suite of materials that show you have a proper regime in place to satisfy your duty. And that's the type of thing you're going to need to do. So members are more than welcome to reach out. We've kind of combined with NatRoads on this particular topic to ensure that members have a very, very cost-effective way, just a kit you can adapt into your business, but you need to be doing something. And ad hoc isn't enough anymore in this space because of the way the positive duty works. And all I can just keep repeating to businesses over and over again is think of it like safety. Think of it like what regime is required to show you've got a safe system of work in relation to forklifts, in relation to long haul work. It's the same now with sexual harassment. And if you don't have the policies in place, the checklists, the risk assessments, then you're probably falling short. And so we really need you to focus on that. In addition to that, if we move to the next slide, there are some prohibitions on pay secrecy. It's now prohibited to, well, sorry, I'll go back a step. Any clause in your contracts that tries to prohibit someone disclosing pay is unenforceable. From 7 June, it will be illegal to have a clause like that in any new contract. So that's an offence, or any contract you vary. So if you vary an existing contract with a pay secrecy clause, you'll need to take it out. So they can stay in your existing contracts, but they're unenforceable. But once you issue a new one or vary one, it needs to come out. employees now have a right to ask other employees about pay, but equally employees also have a right to choose to disclose or not disclose. So basically people can talk about pay if they want. So you'll need to ensure that your contracts are compliant with that. That's probably the pay secrecy point. And just briefly, we're going to now touch just for about 5 minutes on employment and other owner-driver contracts. It is very important in this day and age that you have a written contract. If you don't have a written contract, all sorts of key terms can be subject to uncertainty, whether it's about wages, whether it's about whether someone's obliged to present to work or not and when, or how you terminate the relationship. If you don't have a written contract that spells out how the relationship can be terminated, you can be subject to reasonable notice claims. And so that means that the time that it takes to terminate someone isn't 3 weeks or 4 weeks or 6 weeks. It could be 3 months, it could be 6 months, if that's what a court deems reasonable. And that's the same for independent contractors as it is for employees. When it comes to independent contractors, generally, when you're using owner drivers, you probably need a contract that's going to set out rates, how those rates can be adjusted. Certainly in WA and in Vic, that's an expectation on a contract to ensure that it's not considered a harsh contract under the under the owner driver contract laws in those jurisdictions. You need to have some method of adjusting rates to deal with variable costs that go up and down. You're probably going to want to deal with your expectations around equipment and tracking that's used in vehicles, often to do with driver hours and things like that. You're going to want to deal with the drivers, the drive. Is there a nominated driver for a particular contract with drivers? Is it clear what happens if a nominated driver breaches expectations? Will the company be held liable that you're contracting with? Do you need to approve the nominated drivers for various businesses? So these are all the types of things that need to be dealt with in an owner-driver contract. I think this is just a prompt at this stage for business to think about whether they have the right types of contracts in place. If you don't, obviously you can feel free to get in touch and try and deal with that. And finally, last but not least, there is now limitation on use of fixed-term employment contracts. You can't have a fixed-term contract that goes with employees for more than 2 years. And you can't have a fixed-term contract that gets renewed more than once. So you can renew a contract once, but you can't renew it twice. If you do, that contract will be unenforceable and will be treated as if it doesn't have an end date. That's something to bear in mind for employees only. That doesn't apply to your contractors or your owner drivers. You can have fixed-term contracts with owner drivers and independent contractors, just not employees. I think the only thing on that is to bear in mind there are some exemptions. There's a long list, probably the most relevant pertains to the high income threshold. If an employee driver is earning above the high income threshold, which is currently $162,000, they can be exempt from those limitations on fixed term contracts, but otherwise they keep applying. But I think I just want to reinforce, this is about employee drivers. Owner drivers and independent contractors aren't subject to this regime. Those fixed term contract laws kick in on 7 December, so you can contract at will till then. You can enter into as many and as long fixed term contracts with your employees as you like till 7th of December, but after that date, these laws will apply. I think that's all the content we wanted to cover. I was conscious that we want to give people an opportunity to ask any questions if they have any. Do we have any questions at this stage, Kate?
I'm not sure. I'm going to have to defer to our other co-hosts about whether we've got questions.
No, we don't have any questions yet. Might just give it
Remind
a few
you,
minutes.
Kate, I think you want to just go back to full screen. You're now sharing half screen, but that's all right. We'll just see if there's no questions. We're happy to wrap it up then. That's better.
Yep, there's no questions. There's quite a bit of information there to consider.
All right, well, we're happy to wrap it up on that note. As I said, in relation to...
Oh, sorry, Lewis, I think you might have one.
Dorothy.
Dorothy, would you mind just typing in your question, or I might just see if I can allow you to talk? Just a moment. Here you go. Go ahead.
Yeah, sorry, your chat is disabled.
There you go. You can speak now.
It's still saying disabled, so.
We can hear you.
Okay. With the, I suppose, the fixed term contracts, what happens if a lot of employees actually don't want they want the fixed term contracts on an ongoing basis? They actually like that style. What happens in that instance where it's at the request of the employee?
Well, unfortunately, it will still be outlawed. So you can have one fixed term contract, you can renew it once, so you can have a 6 month, then a 6 month, but then that's it. The employee can't enter into another one, and it can't go longer than 2 years. And they're just now outlawed because the government's formed a view that they're not desirable.
Okay.
And that's the simple position, unfortunately.
Is there, if they hypothetically, if they took out another fixed term contract elsewhere for 6 months or 12 months, what would happen then if they wanted to come back after that time?
They could do that. The contracts, the prohibition is on the contracts going for more than 2 years or renewing if they are broadly continuous. The exact phrase escapes me, but it talks about substantial continuity of employment between one contract and the next. So if they go away for 6 months or 4 months and come back, your time frame would reset.
Okay.
Any other questions?
Thanks, Dorothy. There's nothing typed in, and I don't have any raised hands.
Well, in that case, thank you for your time. There is a bit of content. I'm sure NatRoads can make the slides available to members. I suppose I'll just reinforce, if you are concerned about the flexible work requests, ensuring you have appropriate procedures in place, you want template documents, or you want a suite of comprehensive materials on respective work to put in place a regime in your business, we do have the NatRoads packs we've prepared for members, and you can reach out for information on them. Otherwise, feel free to contact either NatRoads or ourselves, and we'll help you as questions arise.
Great. Well, thank you, Lewis and Kate. Thank you, everyone, for attending today's webinar. This webinar was recorded and it will be made available for members only on the NatRoad website. And if you have any other questions, just send it to info@natroad.com.au and we can pass it on. Have a great day.
Thank you.
Thank you.
Bye.